Hello, everyone. I'm Shawn Garcia, a marketing manager here at Mazars in the U.S. And on behalf of Seyfarth Shaw and Mazars, I'd like to thank you for attending our webinar. Today, we'll be presenting ERISA Litigation, Managing Fiduciary and Service Provider Risk, which will be led by Ada Dolph, Kathleen Cahill-Slaught, Candace Quinn, Rhonda Prusak, and Peter Shablik. Before we begin, I'd like to review a few housekeeping items. First, we encourage you to ask questions. To do so, please send them to us using the Q&A box on the lower left-hand side of your screen. We will try to answer all of your questions during the webinar, but if a fuller answer is needed or if we run out of time, your question will be answered after the webinar via email. Second, to earn the available 1.5 CPE credits during today's webinar, you must listen to at least 75 minutes of the presentation and answer at least 5 polling questions. The polling questions are a series of questions meant to confirm that you are actively attending this webinar. Please note that you must be logged in individually to receive credit for today's webinar. If you are attending as a group, only the individual who is logged in will receive credit. If you've completed the requirements, your certificate will be available to download at the end of the webinar. Instructions on how to download your certificate will be displayed on the screen at the end of the presentation, so please stay on the line. To obtain CLE credit, please complete and sign the form that can be downloaded from the green resources button at the bottom of your screen. A special code will be read out loud during the webinar by one of our speakers, so please pay careful attention. Be sure to record the code on the form and follow the directions. Lastly, you can download a copy of today's presentation from the green resources button at the bottom of your screen. Here, you will also find our webinar frequently asked questions, a document which offers some basic troubleshooting information and other useful tips. Again, this can be found under the green resource list button at the bottom of your screen. Now, thank you once again for joining, and I'll hand it over to Candace.
Thank you very much, Shawn. I also want to thank Seyfarth's co-hosts, Mazars, and Peter Shablik for hosting this event. We are especially delighted to have Rhonda Prusak of Berkshire Hathaway Specialty Insurance join us as our guest speaker. As Shawn mentioned, our topic today is ERISA litigation, managing fiduciary and service provider risk. As we will discuss, ERISA litigation has increased significantly, and our panel of experts will provide insights on this topic, including issues presented, thoughts on reducing risk, what is available for fiduciary insurance, and preventive measures to address cyber risk. Now let's meet the panel. Our first speaker is Ada Dolph, a partner at Seyfarth. Ada?
Hello, good afternoon, good morning, depending on where you are. I'm Ada Dolph, a partner in Seyfarth Shaw's Chicago office. I defend plan sponsors, fiduciaries, and service providers in single plaintiff and class action benefits claims, including extensive experience with the recent type of case that has made a rise, the ERISA 401k and 403b litigation cases. I'll turn it over to Kathleen.
Thanks, Ada. Good morning. I'm here in San Francisco. My name is Kathleen Cahill-Slaught. I'm a partner in the Seyfarth office, and I'm the co-chair of our ERISA litigation practice group at Seyfarth. I've been practicing here for over 25 years and doing all things ERISA. And I have a specialty of also representing Taft-Hartley trustees in allegations of breach of the fiduciary duty, in addition to your regular 1132A1B claims for pension, severance benefits. So I'm looking forward to today, and I'm going to hand this over to Rhonda.
Thanks so much, Kathleen. I'm Rhonda Prusak. I'm with Berkshire Hathaway Specialty Insurance, and I've been there for 7 years. And prior to that, I was in a similar role, heading up the fiduciary liability insurance practice at another insurance carrier for 24 years before that. So I live and breathe fiduciary liability insurance. And with that, I'll turn it over to Candace.
Thank you very much, Rhonda. I am Candace Quinn, Senior Counsel at Seyfarth Shaw in their New York office. I have a specialty practice focused on executive compensation, fiduciary, and governance matters, and I rejoined the firm after a few years ago, and I'm thrilled to be part of this panel discussion. Now let me turn this over to Peter Shablik, partner at Mazars.
Hi, I'm Peter Shavlik. I'm a partner with Mazars. I've been with the firm 6.5 years. My background is heavily involved with consulting and risk management. I was with Arthur Andersen for many years. I'm responsible for the IT audit, SOC, third-party audit support, and anything with audit and controls, as well as certain audit engagements for the firm. Look forward to this session. Turn it back to Candace.
Thank you, Peter. Okay, let's review the agenda for our program today. First, we'll discuss ERISA class action filing trends, and then ERISA litigation developments and Supreme Court decisions impacting ERISA litigation. Then on to fiduciary insurance, and then fiduciary breaches, cybersecurity, data privacy, and preventive measures to address cybersecurity threats. Now, to kick off our presentation, let me turn it over to Ada Dolph.
Thank you, Candace. Okay, so as Candace touched on earlier, we're seeing an increase in ERISA class actions generally. And let's talk a little bit about the volume that we're seeing. Overall, it amounts to about a 10-fold increase in ERISA class actions filed, and this trend started in late 2019 and continued unabated throughout the COVID pandemic. Unlike some other areas of litigation, we continue to see extensive lawsuits filed against 401k and 403b plans, challenging investment options, and I'll get into the typical types of claims that we saw in just a minute. The other trend that we're seeing, which is driving the number of cases filed, is there are additional law firms that have not typically prosecuted these types of class actions that have jumped into the ring and are bringing these cases at times at a very high volume. We're seeing also where in the past only the largest benefit plans would have been targeted. We're seeing now plans as small as 4.5 million being targeted for these class actions. And part of the reason we're talking to you today is that the defense costs associated with these cases do not vary much based on the size of the plan, because they typically require the same types of experts and the same types of motion practice as you move forward. And then compounding the issue is that we're seeing a trend of about 2 of 3 complaints survive early motion practice or motions to dismiss in these cases, meaning they are difficult to be dismissed at an early point, and it's highly likely you'll proceed into the more costly discovery phase with these cases. So as I said, we're seeing a trend of targeting smaller plans. We're seeing new firms get into the mix here in terms of bringing these cases. And the types of claims that we're seeing in these cases are listed here. The first is that the plan fiduciaries did not use the lowest cost share classes of funds. And these types of allegations concern retail versus institutional share classes of funds. Also being targeted is the investment mix that's being offered in the 401k or 403b plan, whether there's enough actively versus passively managed funds, and certainly these lawsuits are alleging that there were insufficient index or passively managed funds offered. The third category of claims that we're seeing very commonly is targeting certain investment options as having underperformed. An easy target for these right now is target date funds, because a target date fund does not typically have the exact same glide path as another provider's target date fund. The performance can vary because one investment advisor's idea of what someone who's retiring in 2035 may differ from another. You're seeing different types of performance and return on investment for those funds. So the allegations are that one particular target date fund underperformed compared to another. We're also seeing claims target funds that are associated with the plan's record keeper. So for example, if your record keeper is ABC record keeper and you have an ABC small cap fund that you're offering in the plan, the plaintiffs in these cases are alleging that there's an impropriety there. And these are newer, bolder allegations and claims that we're seeing in these cases, really challenging some very common and fundamental parts of the way these investment options are offered to participants. Another claim that we're seeing is that it's sort of in the same vein here where they're challenging the very premise of some of the fee arrangements is the argument that a plan should never pay record keeping as a percentage of assets, but should always have a flat per participant fee. And thus far, these claims, some of the bolder claims that I'm talking about here have not been successful, but they continue to be made in these cases. Finally, we're also seeing common allegations regarding that the plan did not perform an RFP or an RFI to check the fees that were being paid by the plan against the marketplace. Okay, so this slide here, the next slide talks about some of the examples of smaller plans that we've seen targeted and some of the types of allegations here. So again, the first case here, less than $250 million in plan assets. The second one is less than $500 million in plan assets. And you see the same types of claims being brought. As I mentioned, we do have some new plaintiffs firms that have gotten into this industry, I guess we would say, and you'll find that there's a remarkable similarity across the lawsuits between the complaints. They're often almost nearly identical. The other thing that they share in common is that they are very extensive. So they often number hundreds of pages in an attempt, as I mentioned earlier, to defeat any early motion to dismiss practice. The next slide here, continuing to talk again about smaller plans that are targeted. I just want to highlight here, there's a plan here that only has 810 participants. So if in the past you felt that you didn't have to worry about this type of litigation because it was really focused on the biggest plans and the biggest players, that is no longer the case. Okay, now we'll turn to talk about some recent ERISA litigation developments, and I'll partner up with Kathleen, who'll go after me to talk about some of the Supreme Court and also predominantly important Ninth Circuit opinions. So the first development that I wanted to talk about is one I've touched on already, the motion to dismiss standard. It used to be years ago that motions to dismiss were more successful in these cases. However, over the years, the courts have begun to focus much more on the process used by the plan fiduciary to reach the decision. And what that means is many of the plaintiffs are filing, as before, very detailed complaints, but they allege that they have insufficient information upon which to identify with any more specificity the supposedly imprudent processes of the plan and the plan fiduciaries. And you have a variance by circuit with how the judges react to those types of arguments. So the first case here that's listed, the Hecker versus Deere, was a really early Seventh Circuit case, which affirmed a dismissal of a complaint at the district court level, finding that there was no fiduciary breach for excessive investment fees, where the plan had 20 main funds, expense ratios between 0.07 and 1%, and it also had a brokerage window, which proved to be key in that case. In contrast, the Eighth Circuit, which began with this Braden versus Walmart case, declined to dismiss these claims, saying that the detailed complaint that had been filed adequately stated a claim for breach of fiduciary duty. So another example, a more recent example of the Seventh Circuit standard varying from other circuits is the Devane case. And the Devane case, again, involved the very similar claims that I've talked about earlier. Here, again, we see the target date funds are targeted as having underperformed. There were in the plan index funds as well as actively managed funds and a brokerage window. And overall, the district court, which was later affirmed by the Seventh Circuit, held that the record-keeping fees were not excessive and the plans were not required to search for a record keeper that could provide record keeping at the rate that plaintiff alleged should have been paid. There, the plaintiff alleged $35, and in this case it was $54 to $87 for one plan and $153 to $213 for another. So The Seventh Circuit here affirmed the dismissal on the grounds that the complaint insufficiently alleged a breach of fiduciary duty. So another example of a differing standard is in the Third Circuit, where in very similar allegations, the Third Circuit in the Suida versus University of Pennsylvania case found that the complaint sufficiently stated a claim for breach of fiduciary duty. There, again, it was a very lengthy complaint, very specific, detailed allegations, and as in other complaints, there the plaintiff offered specific comparisons between returns on a plan investment options and readily available alternatives. And that will get you past the motion to dismiss in some circuits, but not in others. So that's an important factor if you are sued in one of these cases. Another aspect that is continuing to develop is that these cases typically, as I mentioned, involve a battle of experts. When the plaintiff alleges in their complaint that record keeping should have been available or should have been obtained by the plan or plan fiduciaries for a certain number, they often will have an expert testify to that, and then in turn, the defendant needs to obtain an expert who can talk with experience and knowledge about an appropriate record-keeping fee to be paid by the plan, depending on the number of participants in the plan, the size of the plan, and the types of investments that the plan holds. So this can be an extremely costly part of litigation, and Rhonda will talk a little bit more about how that impacts when you have an insurer involved in the case. But this is continuing to be a significant part of these cases. So once you are unable to dismiss the case, you're on to discovery, which includes a battle of experts. Another development that we're seeing play out after an important Article 3 decision by the U.S. Supreme Court is Seoul versus U.S. Bank. And this means that the Article 3 argument is being made in basically every ERISA class action that it can, where a plaintiff is not personally invested in an investment option or is having difficulty showing harm from the investment decisions or the plan oversight. But Kathleen will get into that a little bit more detail in just a minute. Another case that Kathleen will talk about is the Intel case. This one is important because it really makes one of the important defenses much more difficult to obtain for defendants, because it interprets a statute of limitations very, very broadly in favor of the plaintiff and really turns this into a defense that's very difficult to make early in the case and can't be made until later in the case, again, after the more expensive discovery period. And lastly, before turning it to Kathleen, I'll touch on forum selection clauses. So interestingly, out of the Ninth Circuit, we've had another decision. There was an earlier one out of the Seventh Circuit that affirms that you can put into your plan a selection clause, provided it complies with ERISA, which says that lawsuits may be brought where the plan is administered, the breach took place, or a defendant resides or may be found. So tying into what I was just talking about, how the jurisdiction can be so important and impacts the course of your litigation, this would be something we would encourage you to look at to make sure you're including in your plan, a reasonable forum selection clause that complies with one of the options outlined here in ERISA, but also maximizes the defenses that you would have available as a defendant. And with that, I'll turn it over to Sean for our first poll question.
Thank you, Ada. So the first polling question of the webinar is up on your screen, and it reads, in what ways did recent lawsuits bring bolder claims? Challenging 401k plans that offer investment options affiliated with the plan record keeper? Challenging 401k plans for offering actively managed investments when less expensive passively managed investments, such as index funds, are available? Claiming that it's improper for record keepers to have access to participant data for marketing purposes? All of the above or none of the above? Please make your selection now and be sure to click the submit button to get credit for your answer. Okay, we'll give it just 5 more seconds. Make sure you click the submit button. Okay, let's take a look at the results. So 72.7% of the audience said all of the above. Ada, were you going to make a comment on that?
Oh, yeah, that's fine. I was going to mention that, as I said before, we are seeing these types of claims being brought. Some of them, as I said, are challenging really the standard industry practices. And one that I did not touch on, but I know Candace is going to talk more about, is the claim that it's improper for record keepers to have access to participant data for marketing purposes. So that is a newer claim that we're seeing making its debut. Again, it's not been very successful, but we do anticipate continuing to see that as we go forward. And now I'll turn it over to Kathleen.
Thanks, Ada. Good morning. So, yeah, again, good morning again. So I'm here, I'm going to talk about Supreme Court decisions. I'm going to expand on some of the cases that Ada mentioned and talk about some other decisions that we really want to highlight for the audience, so that when you go back to your office, you potentially, in Peter's world, do a little bit of an audit to make sure that you're in compliance so you don't have allegations of breaches of fiduciary duty. The first case that Ada mentioned was the Intel versus Sulema case. And in this case, it was a class action case, and it alleged that Intel's investment committee and the plan administrators, they breached their fiduciary duty by utilizing these alternative investments. And the allegations was that the alternative investments lagged behind high-performing index fund. But the Ninth Circuit granted summary judgment for the committee because they said the plan disclosures clearly revealed these disputed investments and were published more than 3 years before the plaintiff filed suit. But the Ninth Circuit reversed, and this was interesting. It reversed because of Sulema's deposition testimony that he didn't recall reviewing plan disclosures, and that, in fact, therefore created a dispute of fact as to his actual knowledge, and it obviously precluded summary judgment. Affirming the Ninth Circuit, the Supreme Court unanimously found that although ERISA doesn't define actual knowledge, it does require awareness of the relevant facts provided in the plan disclosures. So in this case, the plaintiff didn't have actual knowledge, and so what we want to do here is really learn from this decision, and as my slide says, it actually reduces protections, like Ada said, it reduces protections that the plan disclosures provide, and it's going to create a question of whether or not your plan participants had the actual knowledge. So what some plan administrators are instituting these read receipt notifications and certifications by plan participants that they've actually read the plan disclosures, because Justice Alito, he stressed that even though a participant's assertion that, hey, I didn't know anything about the disclosed information, that's not necessarily the end of the story. Actual knowledge could be proved through inference from circumstantial evidence. So if there are electronic records, then a plaintiff's denial of actual knowledge is going to be blatantly contradicted by the factual record. So that's an important case to learn from, and we are seeing some plans change their practices surrounding plan disclosures. The next case was the Thole case versus U.S. Bank. This case was a decision which highlighted the Article 3 standing to sue under ERISA for breach of fiduciary duty, and this was a defined benefit pension plan, and it's a good case for defendants because they moved to dismiss, which was the district court granted, and the Eighth Circuit affirmed, and then the Supreme Court affirmed that. And basically, the argument is that if you've got a defined benefit plan and you make sort of general allegations of poor investments and losses to the plan, if you can't show that your account, your defined benefit, what is changed, then you have no standing. Whether you win or lose that case, the judge said you're going to receive all your vested benefits and that you're legally entitled to receive. So the plaintiffs don't just have standing, because win or lose, the suit wouldn't change their actually monthly pension benefits. So it's going to be it's a lot harder in a defined benefit world to prove loss and standing if you, in these kinds of cases, because of Thole. So it's from the defense bar, it's a good case to mention here. I'm mentioning this Rutledge versus Pharmaceutical Care Management Association case because we're seeing a lot of, in this case, the court found ERISA preemption didn't apply to this Arkansas statute, which regulated the rate at which pharmacy benefit managers reimburse pharmacies for prescription drug costs. So some of these statutes have popped up, and there's one in Washington, obviously in Arkansas, and basically the judge at the Supreme Court has said that these kind of cost regulations and statutes, they don't interfere with ERISA. There's no preemption of ERISA, and so we might see more states trying to regulate that pharmacy benefit management area and drug costs, and they won't be preempted. So just be on the lookout for that. The next case was also a Supreme Court case. This was involving a Jander. This is a complicated case because the Supreme Court actually ultimately didn't reverse it back to the Second Circuit. But to explain briefly, in this case, the IBM employees, they participated in the ESOP plan, and they sued the Retirement Plan Fiduciary Committee, alleging breach of fiduciary duty. They said that IBM misrepresented the value of its microelectronics division, and thus it was artificially inflating the value of the company's stock, and it caused a drop in the stock price when they sold the microelectronics division. So the plaintiff's claims were dismissed by the district court because the court said that the complaint lacks specific allegations as to why, and this what I want to highlight, this is complicated, so why a prudent fiduciary couldn't have concluded that plaintiffs' hypothetical alternatives were more likely to do more harm than good, thus failing to satisfy. This is the Dudenhofer pleading standard, this more harm than good standard. Now, the Second Circuit reversed. It found that the plaintiffs had pled a plausible cause of action for a violation of ERISA's duty of prudence because they said that the fiduciary's knowledge that the stock was inflated through accounting violations was plausibly pled, and they had the power to disclose these accounting violations, and their failure to promptly disclose them, that caused the true value of the true value to drop. So the Second Circuit held that if the fiduciaries knew that the disclosure of the insider information was inevitable, then delaying the disclosure could cause more harm than good to the ESOP. So it's really these fiduciaries they have information and they don't want to violate securities law, and they can be conflicted. But if in this case the Second Circuit said if you know it and you delay this disclosure, it would cause more harm than good to the ESOP, then that's a plausible claim for potential violation of ERISA's duty of prudence. The Supreme Court, in a per curiam decision, that's why I said it's confusing, because they declined to rule on the merits, and they vacated the case back to the Second Circuit to address these issues of whether or not ERISA ever imposes a fiduciary of an ESOP to act on insider information, and whether ERISA requires disclosures that aren't otherwise disclosed by the securities law. And on remand, the Second Circuit, it just reinstated its original opinion, but it did note that the Dudenhofer more harm than good standard is correct, and it made clear that the ERISA's fiduciary duty of prudence doesn't require a fiduciary to act in a way that violates securities laws. So it's a case to watch. Again, it's something to consider. This more harm than good. If you have the information and delaying disclosure would cause more harm than good to the ESOP, then your fiduciaries are going to really have to think long and hard about that and whether to disclose. The next case I wanted to mention, this is a 401k plan mismanagement lawsuit, and it's ended in arbitration. It's kind of rare for the Ninth Circuit not rare, but the Ninth Circuit is traditionally liberal, and it actually enforced an arbitration provision here. So it essentially allowed Schwab to quash the class action case, and it brought the case to arbitration for Mr. Dormand, and this case lays out a roadmap for keeping fiduciary breach claims out of court and in arbitration. And I just highlight this case because if you do have an arbitration provision within your employment agreement, really look hard at the arbitration provision, compare it to the arbitration provision in Dormand, and if you are encountering a class action, you have a possibility, if you're in the Ninth Circuit, to quash that and just go to arbitration in an individual capacity. Because in this case, the court said that if 502A2 claims are inherently individualized, and they cited the LaRue case. So I mentioned that because it's always a debate whether you're going to enforce arbitration provisions or not, and this is a nice case for enforcing it and obviously saving a lot of money for Schwab and keeping it out of the class action realm. This other case was also in the Northern District of California. This is a Witt versus United Behavioral Health. This case I'm mentioning because it touches on United Health Group's internal guidelines for covering mental health and substance abuse treatment. And in this case, this is a long bench trial, battle of experts, very expensive. But basically, the court found that United Health Group's internal guidelines were not consistent with generally accepted standards of care when deciding mental health and substance abuse treatment claims. So what happened was that United Health Group had to reprocess approximately 67,000 insurance claims. And what I'm mentioning it because you would want to go back and check to make sure your EPA, whoever is administering your mental health and substance abuse treatment, make sure that they're not imposing more strict guidelines than generally accepted standards of care. Otherwise, you could have a Witt situation, and that would mean very expensive and likely a reprocessing of thousands and thousands of claims, depending on your plan, obviously. So it's something to mention. We wanted to highlight a lot of these cases to really give you some fodder for going back to your committee and saying, hey, have we checked out the arbitration clauses in our plans? Have we checked out our guidelines for administering mental health and substance abuse treatment, so that you don't have breached the fiduciary duty coming at you. I'm going to talk about this rising health plan litigation. This is this allegation that of cross-plan offsetting. The courts are kind of all over the map on this. In the Eighth Circuit, the medical providers, and I want to explain cross-plan offsetting is if a medical provider gets paid and gets overpaid potentially, the next claim that the medical provider submits to a plan, even if it's a different plan, the plan can essentially not offset the amount that was paid on the first claim, and so the plan doesn't pay more than it should because it has a hard time covering overpayments to medical providers. So the plan started instituting this offsetting, and there was litigation that ensued, and a circuit handed a win to the medical providers, saying that the practice was a misinterpretation of plan documents. But then in another case for United Health in Minnesota, the court granted United Health motion to dismiss. In that case, in the Minnesota case, it was lack of standing. A bunch of plan participants had sued United Health saying, oh, you can't do this cross-plan offsetting, but in fact, none of the plan participants had any damage as a result of the cross-plan offsetting, so the case was dismissed. But this is another thing we want you to put in your toolbox to check up and make sure everything in your plan is that at least you know the issue, whether or not your third-party administrator or who's administering medical claims, whether or not they are cross-plan offsetting, and if they are, find out what it's all about and make sure that you are informed and make a decision of whether or not you want to keep that practice in your plan. We're seeing some COBRA litigation, and this is very a technical area, but we are seeing problems and cases where plaintiffs are alleging that COBRA notices are defective, and then it resulted in an employee not electing COBRA benefits. So on the slide, there are some issues that have typically occurred in these cases, and we want you to go back and see if your COBRA notice complies with the DOL model notice, and if it has, make sure it doesn't have any of these problems, because the plaintiffs typically seek class certification, and we've talked about with ADA, these cases are very expensive, and daily statutory penalties, in this case for Coburg notices, can quickly add up. The other potential COVID-19 litigation we're seeing is that there could be litigation over you have furloughed workforce and whether or not you continue to offer medical coverage to them. So you want to, you don't want any gaps in coverage. You could have problems there. So you want to make sure you check with both your insurance administrator if you're insured, or the plan administrator if you're self-insured. You may need amendments to your plan. So this just is highlighting again, if you have this furloughed workforce, make sure you communicate clearly what are the continuing premium obligations for the furloughed employees. Mentioned the litigation over mistakes regarding COBRA, and then lastly, if you have a mass layoff, you could potentially have issues with vesting of retirement benefits, because ERISA says that if a retirement plan can have a partial termination with vesting implications for their retirees, if you have more than 20% of plan participants laid off in a particular year, that in fact impacts the vesting of retirement benefits. So you want to make sure you don't have that percentage, otherwise you're going to could have a problem with vesting. I mentioned this unionized employers contributing. I represent a lot of employers that contribute to unionized plans, and you might have a situation during the pandemic where no one's working, and you might need to make sure you report to your Taft-Hartley plan 0 hours or whatever hours they are. But it's important because we're having a lot of reporting lapses and litigation over that with some of my clients, and that's something you'd want to avoid. And now it's our poll.
Thank you, Kathleen. So our second polling question of the webinar is up on your screen, and it reads, ERISA states that when workers sue their employer over benefit plan mismanagement, they are suing on behalf of the benefit plan. Courts have generally interpreted this to mean that workers are seeking judicial relief for the entire plan, not for their own accounts within the plan. Both of the above, or none of the above. Please make your selection now and be sure to click the submit button to get credit for your answer. Okay, we're just going to give it 5 more seconds, so please make your selection now. Okay, let's take a look at the results. So 60% of the audience said both of the above.
Right. So thanks, Sean. So this is getting at this idea that you have to have Article 3 standing. So if you sue on behalf of the plan and you are an individual and you have an arbitration agreement that is broad enough to cover your suit, then you will likely be faced with a motion to stay and pending arbitration, because you can't sue on behalf of the plan in arbitration. Typically. So that's the Dorman case. And then the Thole case is the second question, with courts generally interpreted to mean that if you're seeking relief for the entire plan, not for their own account. So in Thole, they didn't have standing because, again, their own accounts didn't have any damage. So when you're losing the case, it doesn't matter. Even if the fiduciaries completely bundled things and invested in, the Everglades or something, shows my age there, but they will not. It doesn't matter. You're going to get your defined benefit plan. You're going to get your pension, so you don't have standing. So that's what I think this question gets at. And now I will hand it over to Rhonda.
Thank you very much, Kathleen. So it's all the litigation, the different types of litigation that both Kathleen and Ada just discussed. A good time to pause for a moment and talk about fiduciary liability insurance, which really is designed to protect fiduciaries who are sued and who are named in litigation against the types of allegations that the two just spoke about. And you really can't talk about managing fiduciary risks really without talking about fiduciary liability insurance. So ERISA Section 409 imposes personal liability upon fiduciaries to restore losses to the plan caused by their breach of fiduciary duty. So it doesn't matter whether the fiduciary breach was accidental, was inadvertent, was not deliberate. That doesn't matter. The individual who made the mistake, who breached their fiduciary duty and caused the damage to the plan, is required under the law to restore that damage, restore losses to the plan caused by the breach. And so the fiduciary insurance, once ERISA was passed, there was a provision of ERISA Section 410, which essentially allowed for the creation of fiduciary liability insurance because it said that an employer can purchase insurance to pay these losses. And so the fiduciary insurance does just that. It provides a defense, or it reimburses defense costs for claims alleging a breach of fiduciary duty under ERISA. It not only does that, but it also provides a defense and coverage for mistakes made in administering the plan. Further, the policy provides coverage for non-indemnifiable losses of the individual fiduciaries, for the natural person fiduciaries. So where the plan sponsor is unable or unwilling, or let's say the company is in bankruptcy, the plan sponsor is in bankruptcy, they are unable to indemnify the plan fiduciaries, the policy will step in with first dollar defense. So in these cases, the deductible won't even apply. The purpose of the insurance at its most basic is to ensure that no individual natural person fiduciary will ever have to pay $1 out of pocket when they are named in one of these difficult and expensive suits. Further, where the plan sponsor does indemnify, the policy is designed to reimburse or pay the losses of the plan sponsor. Now, the fiduciary insurance is a legal contract, and it has all sorts of definitions in it. In order to trigger coverage, these four definitions in particular must be triggered. The first one I'll talk about is the claim itself. And the claim is usually, it's defined differently in all the different insurers' policy. It's important that you read your insurance coverage closely, or hire somebody who knows how to read these policies, because they do all differ. But all of them have a definition of claim. It's usually several paragraphs long, maybe even a page long. And but at its core, the definition of claim says there has to be a written demand for monetary or non-monetary relief. You have that, you have a claim. The claim has to be made against an insured as defined in the policy. And generally speaking, that would be the directors, officers, and employees of the company. You would not want a policy that requires listing of each individual director or officer, or each employee. You may have a very large company that has thousands of employees in different locations all over the country or all around the world. And directors come and go, as do employees. And you don't know who a fiduciary is necessarily by their title. You determine your fiduciary duties by your function, by what you're doing. If you exercise discretion over the plan, over the management of the plan, and over the disposition of the plan's assets. So you just want coverage blanketly without requiring listing of specific names. And insured under the policy would also be the sponsor organization, and the sponsor organization should also include automatically all subsidiaries of the company without requiring listing. And then the plans themselves are insured under the policy. So any of these parties would have to be named, would have to be mentioned. So let's say the plan committee members who are employees and directors and officers of the sponsor organization, and they're suing with respect to a covered plan under the policy. Plans too, with certain exceptions for things like union plans, Taft-Hartley plans are typically listed on the policy, but otherwise, generally speaking, plans should be covered on a blanket basis. There shouldn't be any requirement for specific types of plans, whether it's 401k plans or medical plans or life insurance plans or ESOPs. There should be really no requirement for specific listing of plans under the policy. Again, that gets very complicated. Plans come and go. They're terminated. They're amended. They're newly created. And so you want blanket coverage for all your plans. The claim also has to allege a loss as defined in the policy, and loss typically includes settlement, judgments, and defense costs. So somebody has to say, well, we've suffered a loss, we expect to suffer a loss, and we need your help. And there also has to be, generally speaking, a wrongful act alleged in the claim. And a wrongful act would typically include a violation of employee benefit law. Employee benefit law would include ERISA. And the broader policies would expand that to not just include ERISA, but also violations of state law. And something that's important for larger companies that have a global reach, that have operations, let's say in Canada or somewhere else. So violations of ERISA-like law around the world is what would be included in employee benefit law. A wrongful act could also include, I mentioned earlier that these policies cover mistakes in administering the plans. And another important coverage that's of a more recent vintage is claims in the insured's capacity as a settler. In the U.S., plan fiduciaries typically wear two hats. They're often the executives of the company, so they wear their business or settler hat. And they also wear their plan fiduciary hat at the same time. And sometimes they make the decisions in their settler or business capacity that can trigger a suit in their fiduciary capacity. For example, a company decides that they can no longer afford to provide retiree medical coverage, so they decide to terminate that coverage, that plan, and that upsets the plan participants, and the participants turn around and sue and say, well, you didn't implement the termination correctly, and you didn't have the right to do that, so I'm suing you. The defense in that case is often Well, I was wearing my settler hat when I made that decision to terminate the plan, and the law says that I am within my rights to do that. And so without this wording in the policy for settler coverage, you may not be able to raise that very important defense. So it's really critical to make sure that your policy has that settler wording in it. But these policies come with exclusions, and I'll talk about some of the more common ones. All the policies out there have what are called the conduct exclusions, and these go toward gaining any profit or advantage to which the insured under the policy was not entitled, or any deliberate fraud, deliberate violations of the law. There's also something that's called a prior acts exclusion. It's not too common. You would typically see this where there's been some kind of transaction at the corporate level, like a merger or a spinoff, where, let's say in the example of a spinoff, where there's a prior acts exclusion placed on the policy for anything that happened prior to the spinoff date. Another one that's very important, there's a lot of confusion about, is the benefits exclusion. These policies are not designed to pay a company's promised benefits. So a company can't, let's say, decide to terminate their benefit plan, and then when they're sued, turn around and say, well, my fiduciary carrier will provide the benefits that we decided that we had promised to our employees and then decided to end. That's not what the policy is designed to do, and that's not what individual fiduciaries are held liable for under the law. The policy is truly designed to restore losses caused by a breach of fiduciary duty. So, for instance, like some of those cases that are so common now, let's say those 401k fee cases that allege that damage was done to a plan because of a breach of fiduciary duty for failing to reduce fees associated with the plan, for failing to invest the plan assets prudently. So those are the types of claims that would be covered, but not where a company decides they have a traditional defined benefit plan and they suddenly decide to cut the monthly benefit from $1,000 to $500 and say, well, let somebody else pay for that. That's not what's meant to be covered. Specifically addressing the fee issues, the 401k fee issues, these have become enormously expensive. Ada spoke about how common these claims are becoming, how they're going more down market, smaller and smaller plans are being hit. These litigations are enormously expensive. As Ada mentioned, only 1 out of 3 cases is successful in the motion to dismiss, but even then, most of those cases will be appealed or refiled in some fashion. But just to get to the motion to dismiss can easily cost several $100,000. And once the case gets past the motion to dismiss, regardless of the size of the plan, so whether the plan has $100 million in it or $1 billion or more in it, once you get past that motion to dismiss, the defense expenses will easily run in the millions. Very easy to get to $5 to $7 million just in the next phase, in the discovery phase of the litigation. So these have become very, very expensive cases for insurers, and they're reacting. They're reducing the amounts of insurance coverage that they'll put up. In certain cases, you might even see full excessive fee case exclusions. That's pretty rare. They might put up a separate retention or deductible or a sublimit. So let's say there's a $10 million policy. Maybe they'll only offer $5 million for fee cases. Or they might put on some kind of wording to limit their exposure toward mass and class and derivative actions. How do we underwrite to this? Most of the carriers have come out with fee questionnaires, and what they're trying to do is to really assess the plan fiduciary's plan governance, and how robust their processes are with respect to fees and investments. How do they assess the reasonableness of fees? We understand fully that nobody has to guarantee the lowest fees. Nobody has a crystal ball, and nobody can know exactly how investments are performing, but they have to provide evidence and be able to provide evidence that they were really doing the right thing, that they had robust conversations, they were thoughtful in their decision-making with respect to investments and record-keeping fees and investment management fees, especially with respect to those target date funds, which are often the default investment option in the plan. When those target date funds are expensive and when they're actively managed rather than being passively managed, that's been a source of quite a lot of litigation. And then other issues that we underwrite to, we look at the financial condition of the sponsor organization. We look to see whether there are layoffs, plan terminations, any cutbacks in benefits are going to upset plan participants. In defined benefit plans, we're looking at whether mortality assumptions are very old and dated. Have there been early retirement windows? And something that Candace will be talking about, how the newest exposures, how our clients are handling cyber exposures. And with that, we're going to go to our next polling question, and I'll hand this off to Sean.
Thank you, Rhonda. So the third polling question of the webinar is up on your screen, and it reads, can a fiduciary be personally liable for breaches of their fiduciary duties of loyalty and prudence? Yes or no? Please make your selection now and be sure to click the submit button to get credit for your answer. We'll give it just a couple more seconds. Okay, let's take a look at the results. So 77.8% said yes.
And the answer here is yes. ERISA is clear that fiduciaries can and will be held personally liable for breaches of their duty, and it's because of this that the plaintiff's bar knows they'll be very successful in scaring the living daylights out of plan fiduciaries by naming them personally in these suits. And with that, I will turn the presentation over to Candace.
Thank you very much, Rhonda. In our next section, ERISA fiduciary breaches, cybersecurity, and data privacy. In the U.S., retirement savings that are held in defined benefit plans, with 34 million participants in the private plans, and defined contribution plans with 106 million participants, have an estimated $9.3 trillion in assets as determined by the Department of Labor. Due to the significant amount of these funds in these accounts, theft of participant retirement assets and confidential private information, including financial data, is a significant target for identity theft and fraud transactions. Now, there's been a huge increase in ERISA class action data discussed and some cases included allegations of fiduciary breach for cross-selling that confidential participant data. Now, ERISA is silent on data protection in the form of electronic records, and there's no comprehensive federal regulatory provision governing cybersecurity for retirement plans in the U.S. And recent ERISA litigation has included these allegations that increased use of confidential participant data by record keepers is being used to cross-market without the participant's knowledge or approval. And this includes accessing the plan participant's contact information, financial data, investment preferences, age, and date of retirement. Now, ERISA does not specifically address if participant data is a plan asset protected under ERISA. Although ERISA does not outline the specific rules protecting data, the Department of Labor, which is the enforcement agency for ERISA, has recognized risks associated with electronic communication of plan information and directed plan administrators to take appropriate action to protect that confidential data. So not only has the DOL recognized the risks, recently the DOL released guidance on safeguarding retirement plan assets from cybersecurity theft. The guidance for plan sponsors, plan fiduciaries, record keepers, plan participants consisted of 3 documents. The first document was tips for hiring a service provider, with questions to ask the provider before trusting them with your plan's assets, and monitor their activities, including audits. The guidance included information to be sure of the provider's use and sharing information and confidentiality. Now, the guidance provides that the contract with that service provider should spell out the service provider's obligations to keep that private information private and prevent the use or disclosure of confidential information without the written permission of the participant and meet the strong standard of care to protect confidential information against unauthorized access, loss, disclosure, modification, or misuse. Now, the second document the DOL provided was a cybersecurity best practice to avoid being targeted by cyber criminals. And in it, it recommended that a company should conduct a risk assessment by an independent third party on their company's cybersecurity controls. And Peter will discuss more on that under his section on preventive measures. And in the third document, Online Security Tips, it was recommended that steps be taken to avoid fraud and loss of retirement assets, including training participants, but still fiduciaries have the duty to keep the plan safe. Now, individuals have trillions now of dollars in retirement plans, as well as confidential sensitive personal information, which is a target for identity theft, and transactions are taking place online, creating opportunities for cyber criminals. It's important to a sound cybersecurity program to identify and assess internal and external cybersecurity risks that may threaten the integrity and confidentiality of stored data. So what does ERISA protect? Well, monetary assets of a participant are plan assets, and a fiduciary must take steps to protect that from cyber breach. Now, whether a failure to protect retirement plan financial assets is a fiduciary breach can depend on whether the financial data is considered a plan asset. Now, it's the DOL's position that assets of a plan are generally to be identified on the notions of property rights under non-ERISA law, and that is based on a DOL advisory opinion from 1992, which contains several tests that could be used. Now, participant plan data, plan information, the courts look to determine whether it had value or if it was treated as a plan asset. Now, due to the focus on the value of personal data in our current society, a recommended approach is to take careful steps to protect that data. Yet, class actions continue, and lawsuits include allegations of fiduciary breaches for failing to safeguard the confidential data. So what has been the result of those settlements? Well, there one ERISA class action settlement, the sponsor prohibited the plan's record keeper from soliciting the current plan participants to cross-sell the data, and they could only use the data where it was particularly requested and approved by the participant. In another case, it was determined by the court that the personal information of the plan participant is not a ERISA plan asset, as it's not personal information that the plan participant can be considered as property that could be sold or leased, following the DOL notions of property rights. Now, ERISA class actions have continued with a focus on excessive fees and including these allegations that the record keeper is using the data to aggressively market their financial services and products. The allegations against the record keeper are that they're selling the data to replace lost or reduced revenue from retirement fees. Now, in a ERISA 2021 class action alleging excessive 401k fees with allegations that the record keeper breached its fiduciary duties to the participants by sharing the participant data with an affiliate for the benefit of the record keeper and not for the exclusive purpose of benefiting the participant or its beneficiaries. Then the court in that case looked at the text of ERISA, and the court found that assets include investment assets, but not data. And it cited to other courts' decisions which looked to notions of property rights, but acknowledged that confidential data has some value. So more ERISA litigation is expected. What can a fiduciary do? There's no federal statute specifically addressing retirement plan cybersecurity obligations, and ERISA, which was enacted in '74, is silent on data protection in the form of electronic records. Yet a majority of states have statutes regarding privacy and cybersecurity. And ERISA fiduciaries have a strict duty of prudence and loyalty. So as the class actions continue, what can a fiduciary do? Well, fiduciaries should take steps to protect the data and safeguard electronic access to the monetary assets, be educated on the law, and negotiate cybersecurity protection in the service provider's contract to protect the participant data and account balances. Read the contract. Make sure it contains privacy and data protection, and make sure there is a contract and it's not just marketing material. And ERISA counsel can be helpful in reviewing the contract and can also help to conduct RFPs, which should be conducted regularly. Now, fiduciaries should monitor the service provider to determine if they are cross-marking the data and limit their access. Fiduciaries need to understand the eternal risks associated with transmitting data to service providers and be mindful of their fiduciary duties. So, key takeaways from this discussion: be proactive. Planning in advance is an extremely important part of addressing a cyber incident and complying with your fiduciary duties. Rely on experts. There's a duty to stay reasonably informed. Seek out expertise to evaluate and mitigate risk. And consider the type and amount of insurance, cyber risk and fiduciary insurance, as Rhonda discussed. And stay current. Businesses must stay current and align policies with ever-changing legal landscape and industry standards to reduce risk. And we have another polling question.
Thank you, Candace. So the fourth polling question of the webinar is up on your screen, and it reads, do you review internal controls to address data privacy and cybersecurity to prevent breaches? Yes or no? Please make your selection now and be sure to click the submit button to get credit for your answer. I'll give it just a couple more seconds. Okay, let's take a look at the results. 100% said yes.
Okay, well that's excellent, because the DOL provided review of cybersecurity controls is important to ensure a sound and secure cybersecurity system to protect those retirement plan assets and confidential information. So now let me read the CLE code. It is SS, like in Cypher-Shaw, SS 4882. 4882. And now it's my pleasure to turn the presentation over to Peter Shablick to address preventive measures to reduce cybersecurity risk.
Thank you, Candace. This is Peter Shablick. Again, I'm a partner with Mazars, and I've learned a lot in this session. I'm not on the front end, or I should say I'm not on the legal side. I'm on the advisory, preventive side, and that's what I'm going to talk about a little bit. You've heard about all the things that can go wrong. Now, what can you do to anticipate and prepare to minimize the risk? You know, we've heard how a fiduciary, a plan sponsor, can be liable. A company can be liable for their sponsor, their external sponsor. What are the things you can do? We've heard about it. What did we hear about today? We heard about, not having a periodic RFI or RFP process, errors, fiduciary due diligence, not selecting the lowest price, record keeping fees. Those are all items that can actually be managed. There can be programs can put in place for that. And then the last Candace who spoke about privacy and confidentiality in cyber best practices. What can you do in those? Fiduciaries and management, they may not be experts in these areas, but what can they do to put a program in place to minimize the risk to their organization is what I'm going to talk about. The first thing I'm going to talk about is third-party risk management. Third-party risk management is a program and a practice that's adopted by companies to minimize risk of reliance upon third parties. It can be very broad. When you talk about healthcare, you talk about manufacturing, supply chain. You talk about a lot of different things, but for our purposes here, we're really going to talk about third-party risk as it relates to privacy, confidentiality, security of data. What can you do for that? The other thing about third-party risk management that is really relevant is if you have a program in place, how are you vetting your beneficiaries or other third parties? Do they have a privacy program? Do they have business practices in place to operate to minimize your risk? This is what a third-party risk management program can do. In today's world, we're talking about ERISA, but in today's world, we're more and more reliant upon third parties. I can remember years ago, in the early 90s, when payroll was the first non-core process to be outsourced. But in today's world, it's very common to outsource. Instead of trying to build that skill base and have that cost internally, whether it's benefit administration, which we have a number of clients in the area, or it could be payroll, or it could be insurance claim processing, it could be expense management. A lot of areas where it really doesn't make sense for a company to invest in those skills, those resources, the non-core to their business activities, and they can't do them better. They can't get the scale, and they can't get the cost down, and they can't have the capabilities as a third party. So there's a lot of reasons to do this. But in terms of third-party risk management, it also poses risks. Just because you outsource doesn't mean the risk goes away. You're still responsible for oversight, especially as we said earlier with ERISA, but for other areas, you're still responsible for oversight. You may outsource tasks, but you can't outsource responsibility. So third-party risk management program, associated with vendor risk management vendor program, really helps in evaluating who your vendors are and where your third parties are. In terms of our approach, we have a three-step approach. We help companies assess their current process, put a program in place, and establish ongoing monitoring. What does that mean? You first got to find out who your vendors are, ERISA and others. What are the risks they expose you to rather? Again, I'm focusing on security, privacy, and confidentiality. What are the risks? What kind of data do you share with them? What kind of access do they have to your systems? What kind of confidential information, which could be business confidential, like trademarks and intellectual property, or private information, as we heard earlier, names, social security numbers, date of birth, those kind of things. What information is shared, and what are the risks? And then from there, obviously, what kind of controls and monitoring do you need to put in place? There are a lot of technology solutions that facilitate this. This concept of self-service, where we do this for our clients do this, where we have to actually answer the questions and provide evidence ourselves, where it mitigates the burden on companies if they have a system in place to do that, as opposed to somebody manually doing this. But it is an important aspect. And does it prevent everything? No, but it does show that you've done due diligence in terms of evaluating your vendors and putting a program in place. So third-party risk management, again, is a concept methodology that is employed by more and more companies. We see it very common in regulated industries, banks, insurance, but it's really going out to all industries because the exposure is out there. When you're relying upon third parties, you've got employee information as well as customer information and other information. So third-party risk management is an important concept. Sean, I'm going to let you go to the next slide.
Thank you, Peter. So the fifth polling question of our webinar is up on your screen, and it's a true or false question. Third-party risk management, TPRM, does not consider the security and confidentiality controls of an organization. Please make your selection now and be sure to click the Submit button to get credit for your answer. We'll give it just 5 more seconds. Okay, let's take a look at the results. 100% said false, Peter.
That's correct. There's the word not. Whenever you see the word not in a statement, right? So they answered that correctly. It does consider. It does consider. So people are listening, as we said in our last event we had. The other, in terms of what does a third-party risk management process entail, as we talked about, this is kind of a schematic that shows the approach. First, setting up governance, having the right level of management, the right resources, right oversight. Just like a lot of other programs in place, board oversight, management oversight, who's the sponsor and how is it managed. The next one is really doing the inventory. Do you know who your third-party risk management exposures are? I did a project. It was more of a vendor project for an insurance company in Hartford years ago. They had 10,000 contracts, and 100 of them with IBM. And they didn't realize at the time they had duplicate, triplicate contracts with the same vendor. Large organizations, you might go in there, you find a lot of legacy things that need to be cleaned up. But starting off with a third-party, with an inventory is critical. Doing a risk assessment. What are your risks? Some vendors may not expose much risk as it relates to security, privacy, confidentiality. I dealt with a law firm and the cleaning crew. They were low risk, but they still had risk because they came in and they could see things on the desk. So it's very important to have a clean desk policy for many organizations. But, or it could be high-level risk, it could be healthcare provider benefits. So you've got to look at the risk, do a risk assessment. That's not all vendors are the same. Establishing the right level of controls for the vendors. Policies, procedures, and having a program in place that makes sense, and meeting local regulations. And then, looking at the contracts and looking at the sourcing, making sure your contracts are adequate, make sure the clauses are correct is the next step. Doing the actual risk rating. And then the final one is automating and reporting, putting an automated solution in place so you can minimize the manual effort and maximize the efficiency of the program. TPRM is an important program for many clients or most organizations these days to really understand who your vendors are and put management control around that. The next slide I'm going to talk about is what it doesn't do, though, it doesn't offer an opinion. In many cases, for a fiduciary to sleep well at night, they want somebody backing them with an opinion. In our opinion, your controls are fairly represented, your processes are tested. And so what can we do? From an audit perspective, we can do a SOC report, Systems and Organization Controls. It used to be called the SAS 70. This was formed in the early 90s, but it's really evolved quite a bit over the years. 2 forms. One is financial, which is SOC 1, which is an auditor-to-auditor communication. So when a company is doing an audit, again, a SOC 1 report, and they don't have to test the controls around the service organization, such as ADP, for example. ADP has many SOC reports, and instead of every customer that uses ADP auditing their operation, they can rely upon a SOC report that's performed within AICPA standards. SOC 2 is really, we're going to talk about more today, and that's really non-financial controls. It's dealing with privacy, confidentiality, availability, security, and processing integrity. So with a SOC report, or SOC 2 came out, I think in 2014, I believe, and what it was is for non-financial users, how do we gain comfort that our data is controlled? We have the service organization has controls over that. So for a standpoint of ERISA, if you're dealing with we talked about RFIs and RFPs, if you're dealing with a third party, you probably want to make sure they have a SOC 2 or equivalent in place. You don't want to, the fiduciary doesn't want to be losing sleep at night that the data may not be protected. But SOC 2 is something that's a given standard in the industry these days, especially for third-party benefit providers. Again, that provides comfort on terms of confidentiality, security, privacy, processing, integrity, and availability. The big ones there are privacy and confidentiality, and privacy deals with personal information. Confidentiality deals with more trade secrets and more business confidentiality issues. But what it is, again, it's a report that is an opinion by a third party. So we do these, we take these very seriously in terms of scoping and testing and verifying, so that we can say that the controls are presented fairly. The SOC, there's three levels of the SOC. There's a SOC 1, financial, as I said. SOC 2, which is, again, I'm not going to repeat the confidential, security, privacy. The SOC 3 is kind of a tailored down SOC 2, which is available to go on a website, so you can actually, as opposed to the others are restricted distribution. SOC 3 can go on a website and it can be shared. SOC 2, again, is for the user organizations, management, and their auditors and boards. So the process are much different. But again, this is an opinion. This is actually a signed opinion. The the intent of the audience is slightly different. As I said, SOC 1 is for auditors. SOC 2 is for user entities and business partners, as well as a SOC 3. It's very similar. There's two versions of a SOC. There's a Type 1 and Type 2. Type 1 is a point in time, whereas these controls exist at a point in time. And a Type 2 is over a period of time, usually 6 months. The Type 1 really includes 3 opinions. The controls designed, adequately designed. Do they prevent the risk? Are they presented fairly? And essentially, is what it said really happening? And are they placed in operation? So as of date, with a Type 1 has to be placed in operation. For Type 2, it's operating over a period of time. So why would you do a SOC 2? There's a cost, there's time, there's effort. Well, there's a lot of reasons in today's world, especially if you're a provider of service. There's a big competitive advantage or a competitive disadvantage. If you're in payroll, for example, you have to have it. If you're providing certain bank services, you have to have it. Insurance. But other industries, we're seeing more and more, it's a competitive advantage to have it when others in the industry may not have it. I know our firm is a big difference, as we have a SOC 2 for the public accounting firm. We have it done. So really is a big competitive advantage. It's also cost reduction. They may seem counterintuitive, but we have some clients that if they didn't have a SOC 2, they'd have dozens, if not hundreds, of users visiting them, making them complete checklists, and then really doing a very thorough review. It provides better service. You've got a benchmark to measure against. It increases trust with your customers. Your customers see that a third party has come in, not only assessed, but evaluated and provided an opinion on their environment. It engenders a level of trust. And you're meeting the contract requirements of and expectations of stakeholders. The SOC 2, unlike we talked about PPRM as a program, SOC 2 is an opinion. It's a attestation. We can put in there, as it relates to business controls, quite a bit about requirements in the business, so you can attest to contract requirements in there. And you're addressing a broad range of risks in the area. I think that was my last slide. Sean, if you can go to the next slide.
Thanks, Peter. So the final polling question of the webinar is up on your screen, and it's, again, another true and false question. And it reads, SOC examinations provide readers with an opinion on whether controls are designed effectively, fairly represented, placed into operation, and in the case of Type 2 examinations, operating efficiently. True or false? Please make your selection now and be sure to click the Submit button to get credit for your answer. Okay, we're going to give another 5 seconds. Okay, let's take a look at the results. 71.4% said true.
Well, they're right. They provide an opinion. SOC 1s provide an opinion on whether controls are designed effectively, fail to present in place in operation. In the case of Type 2, which is normally a period of 6 months or more, it provides an opinion on operating effectively, whether controls are operating effectively. That's really, in many cases, that's what really provides the value, that you actually can say the controls are not only in place but operating.
Great, thank you, Peter. So we're going to pass it now to Candace for any audience questions.
Okay, thank you, Peter and Sean. It looks like maybe you have time for 1 or 2 brief questions. We have one here for Ada or Kathleen. What are the top 3 things the fiduciary should be doing to ensure they are well positioned if a lawsuit is filed? Kathleen,
I'm happy to start, Kathleen.
Well,
you want to
go
chime
ahead,
in?
Yeah.
There's probably more than 3.
Yeah.
So from my perspective, when I'm defending these cases, what the court is looking for is a record that the fiduciaries were paying attention and considering the issues. And of course, the other half of that is that if the fiduciaries have done that, that there's adequate documentation of that process. So I guess I would offer that I would start with a review of the governance of your plan. Take a look at the committees. Are they working effectively? Do you have documentation that shows, if you're pressed, that in a lawsuit that they've been meeting regularly, following the procedures, following the investment policy statements, and all the other applicable documents? And I would say another recommendation I would make is that if you are doing that sort of review, that you consider doing it from a settler perspective, working with counsel, so that the examination is potentially privileged. If you're doing this type of review, or if the committee undertakes the review, it's likely not going to be privileged, because the doctrine is that the advice will be given in the interest of and on behalf of participants, so they would be potentially able to see whatever the outcome is of that review. So just consider involving it more from a fiduciary risk liability side and having a plan settler engage counsel. The other thing that a committee should do, that fiduciaries should be doing potentially in their fiduciary capacity, again subject to the limitations I just said about engaging counsel, is to ensure that you've really taken a look at the fees that your plan is paying. If you are paying on a percentage of assets basis, you should be sure that you've got a record of evaluating that fairly regularly, and that you understand those fees. Half the battle is really understanding those, and a court will look for that understanding and then oversight from the fiduciaries. Part of that could be my third thing, which is to consider, if you haven't done one in a long time, some sort of RFP or RFI to really pressure test the fees that you're being charged by your service providers. And with that, I'll turn it over to Kathleen if you have anything further to add.
Ada, that was very comprehensive, and I just want to stress what you said, that process is prudence. So the worst thing, you can go into a lawsuit and you ask for the administrative record of considering certain investment options or claim decision, and you don't get anything, or you get a very scant record. It's more important to make sure you document your considerations, so that a court, if they ever have to look at it, says, well, they looked at that, they considered it, they dismissed it for these reasons, and that was they fulfilled their fiduciary duty. I think we're up against our deadline here, so I'll pass it back to Candace.
Okay, great. Thank you very much. I don't know if we could just I have one more question. I don't know, Rhonda, if you could just tell us quickly, how much fiduciary insurance should we purchase?
that's actually not an easy question to answer, but what I can say is that the more issues that you have, the more insurance you should purchase, and so if you have fee exposures, if you're in the sweet spot for the plaintiff's bar right now, which is anywhere from, let's say, $100 million in 401k or 403b plan assets and up, and if you haven't done an RFP in a long time, or if in fact you have recently done an RFP, you should probably get an amount of insurance that's at least equal to 10% of your plan assets at least. There's never any need to match the amount of insurance to your amount of plan assets. So a $100 million 401k plan does not need a $100 million tower of fiduciary insurance. But certainly an insurance broker is equipped to provide advice on that question.
Okay, excellent. Thank you very much. I see we're running out of time, so first I want to thank everyone, Rhonda, Peter, Kathleen, Ada, Sean, and thank all of you for joining. And I also want to thank our hosts, Mazars and Cyfarth, and special guest speaker from Berkshire Hathaway Specialty Insurance. Now let me quickly turn it over to Sean to provide closing comments, and please stay safe all and be well. Thank you very much.
Thank you, Candace. So I'd like to thank all of our speakers on behalf of State Farm Shore and Mazars. We hope everyone enjoyed today's webinar. If you've completed the CPE requirements, your certificate is now available for download. You'll see the instructions on the screen. If you are a Mazars employee, no need to download the certificate. If you need CLE credit, don't forget to download the form from the green resource list button at the bottom of your screen and follow the instructions. We also encourage you to tell us what you thought about today's webinar by completing our feedback form, the link to which you will see on the screen shortly. Please take a minute and click that link once we conclude here. Again, please feel free to reach out to any of today's presenters or myself with any further questions. Thank you once again and enjoy the rest of your day.